All right, we're now back on YouTube Live. This is Clayton County Magistrate Court preliminary hearing calendar. Today's date is March 18th, 2026. This is the state of Georgia versus Raymond Woods Jr., warrant number 2026 WA 03634. All parties are present and have announced ready to proceed. 88 Thomas, you can present the state's case.
Thank you, Your Honor. Officer, could you please raise your right hand? Do you solemnly swear and affirm that the evidence you should give before the court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can put your hand down, state your name for the record.
Jordan Lewis
How are you employed?
at the Riverdale Police Department.
And were you so employed on or about February the 18th of 2026?
Yes.
Did you have occasion to respond to a 6-3, I believe it's 9-8?
6396.
Okay, Valleydale Drive, Riverdale?
Yes, ma'am.
And is that within the confines of Clayton County?
Yes, ma'am.
And what's located at that address?
Residence, a home.
And did you have occasion upon arriving at their residence to conduct an investigation involving a Raymond Woods Jr.?
Yes, ma'am. We received a call of a domestic disturbance where Raymond Woods Sr. had called stating that his son was at the location in violation of a temporary protective order.
Okay, hold on one second. Judge, Mr. Woods Sr. is in the courtroom, but I would like to invoke the rule of sequestration.
If you could have Mr. Woods just remain right there outside the hallway until then when we get to his portion of the case, we'll call him back in. Mr. Woods, just step back outside the door. We'll call you back in when it's time for you to testify. Woods Sr., yes.
If he just goes in the vestibule, Your Honor, he can't hear a thing.
Come on.
You can hear in that vestibule.
Judge, your ears are better than mine. I never could. Okay. Officer?
Yes, ma'am.
Now, what happened when you arrived at the residence?
We spoke with Mr. Woods Sr., who stated that his son was, he believed to be intoxicated, and he was scared that his son was gonna, I believe he said, jump on him again, which there was a previous case there where he got the temporary protective order. Mr. Woods Sr. had the protective order in his hand. Myself and other officers read the protective order and determined that it was valid. Mr. Woods Jr. then came outside where he was detained, and we asked him about why he was there and everything, and he said that his father had allowed him to be there in and out over the past couple months, but due to the protective order, he was not supposed to be there.
So Mr. Woods Jr. acknowledged knowing about the protective order?
Yes, ma'am.
Now, did Mr. Woods Sr. provide you a physical copy of it? Like
Yes,
a
ma'am.
paper?
Yes, ma'am.
And could you tell whether or not Mr. Woods Jr. had been served with a copy of that paper or had read that paper?
I don't know if he had been given a copy, but he was aware of it. He knew that he wasn't supposed to be. He knew that the temporary protective order was in place when I asked him about it.
Did he advise what actually happened to make Mr. Woods Sr. call the police this time?
Mr. Woods Jr. was becoming aggressive and getting loud with his father, Mr. Woods Sr., and it made him scared that what happened before, where he jumped on him, would happen again that night.
And you mentioned before, have you actually responded to that location before? Or how do you know about the previous history?
There's a previous report done there that I looked at while I was on scene, where Mr. Woods Jr. had, I don't want to use the wrong terminology, but it put his hands on his father.
Objection. Judge, at this point, we're getting, for one, I'll say I'm not sure what the relevance is. Like I let it go a little while because there was a reference to it, but the more we get into it, the less relevant it is to the particular case at hand.
Your Honor, may I be allowed to respond?
Yes.
Unfortunately, Your Honor, this is relevant because one of the components, which I have learned the hard way, of aggravated stalking is history. And that history is relevant to an aggravated stalking as opposed to a regular stalking or anything else. And that's what the officer is testifying to now, that that previous history between the parties.
And Judge, what I would say is that it's not history that's relevant. It's not just any history. It's about history that would be relevant to stalking.
And that
Just a mere disagreement, altercation, any of that, that in and of itself is not relevant to stalking. Stalking is a very specific course of conduct. It's about surveillance, harassment, intimidation, things of that nature. So just the fact of a disagreement is not relevant to stalking.
Well, we're here about the aggravated stalking, which means it has to be an order in place about the current incident that we're here for.
and I
Correct?
believe that is correct, Your Honor.
Okay. All right, so we don't have to go into all the details about the previous one. The fact that it's a TPO that's issued, the court will take judicial notice that the court found that it was probable that some acts of domestic violence have occurred.
Okay. And officer, were you able to get a copy of that previous TPO? Not of the TPO in question here?
It was recorded on my body worn camera. I flipped through it. I don't have a physical copy of it, no.
Okay. And do you know if it was filed through Clayton County courts? Do you recall?
Yes, ma'am, I believe so.
And did it require this defendant to stay away from the home of his father?
Yes, ma'am.
And when you talked to him, was he at his father's home?
Yes, ma'am.
I might have asked you this previously, but I'm going to ask it again just in case. Do you know if he was actually served with that previous copy? Was he able to show you that?
He was not able to show me that he was physically served with the copy, but he acknowledged knowing that it was in place.
Okay. Was Mr. Wood Sr. harmed during this incident?
No.
Okay. Your Honor, I think that's all I have at this time. I do have a document that I need to scan it and send it to Mr. Rogers and to the court.
Okay.
Give me 1 second.
All right, while he's doing that, courtroom 202, could you all put Mr. Mundele's client in the breakout room, DeAndre Smith? You must be a one-man show today.
I'm back.
Okay. Did you emailed it?
I'm emailing it as we speak, George.
All right.
It should be on its way. Mr. Rogers, did you get it?
Yeah, I see an email. Let me see if it opens.
Yeah, I received it as well.
Thank you, Judge. Judge, what I just sent was a copy of the proof of service that's filed with the Clayton County Superior Court in this particular case.
And I would object for one, it's not a certified copy for one. For two, it's not this witness's document or anything like that. So nobody's testified about the circumstances or anything like that. Additionally,
Judge,
I'm
if I
not-
may be allowed to respond.
He was still talking when he finished.
I'm sorry.
yeah, if I'm not mistaken, there's been no testimony that would allow us to like say whether or not this is relevant, because this officer hasn't said what TPO he was there about, when it was effective as of, or anything of that nature. And part of the reason I'm saying that is because I'm aware that there's, for one, at the very top of the page I'm looking at, it says date November 10th, 2025, but then it says the signature line is the 22nd of October. Now, unless I don't know my calendar, I'm not sure how you could have served something of November the 10th on the 22nd.
That's the court date.
Right, but then it's not relevant of anything then if it's not an actual TPO. So I don't know the relevance then at this point. If it's just notice of the court date.
So it looks like he was served the ex parte, not the actual TPO, because that won't happen to the court date. So this is only notice that the ex parte was served.
Right, I understand, Judge. What I'm saying is there's a November the 10th court date. This ex parte.
Okay. I see what you're saying. I understand your point. Your point is that this is proof of service of the ex parte order, but not the actual protective order that was issued on that court date or whatever court date.
Right.
Okay, I understand your argument now. All right, Ms. Thomas, your response.
Judge, what I wanted the court to see was the fact that this was an order in progress. This ex parte covers everything up to the point that the permanent order is issued, at which time this defendant would have been on notice to stay away from his father's residence. The permanent order itself that he acknowledged knowledge of, that the officer did in fact review,
Judge, I'm
not using it, if I may be allowed to respond.
I have to object because that wasn't testified to. There was no testimony about what specific order or anything like that. There's just been vague references to an order.
I don't think I specified an order one way or the other. Other than the officer did the order that the officer reviewed. That's all I said. I didn't say any specific one. Because actually there have been more than one.
That's my point.
But in any case, the defendant did acknowledge that, and he probably acknowledged it because he had already received.
Again, Judge, I'm objecting because that was not testified. It was not testified that he acknowledged this order or that order or any particular date or anything of that nature. And she's trying to specify like it's this one, but that's not what was testified to.
What the officer testified to, Your Honor, was an order that was in place at the time that he responded. I believe the officer's testimony specifically was, we verified that that order was in effect at the time that we were there. And that it was his impression, based on conversation with Mr. Woods Jr., that he was aware of that order that was in place at the time that the officers were there. This proof of service covers the ex parte and all the paper documentation that led up to that permanent order being generated. This man knew that he was not supposed to be at his father's residence. And that was why the reason why the officers took him into custody on that date. Now, Your Honor, I don't think I've turned over the witness yet. I just wanted to get that particular document before the court and for Mr. Rogers to review. And then I was going to follow up on that with the officer.
All right. Do you have a final response, Mr. Rogers?
Yes, ma'am, Judge. Again, what the ADA is claiming is not consistent with what was testified to. She's talking about Mr. Woods has acknowledged this order. There's no number given. There's no date given. So there's no way to say that he acknowledged this order or any other order. And additionally, again, this is not an order. This is not, at least I would say it's not from what I can, let me take another look at it. But from the orders I've seen, they're a little bit longer than that. And they talk about all the various places you're not supposed to be in, who you ain't supposed to be around, and all that.
I did not send an order. I sent a proof of service. That's it.
Right.
All right,
And that's the point.
it's okay. I'm ready to rule. I've heard enough. I've been sorted through this. I'm gonna sustain the objection as there is no clarification. The testimony was that he went out there and spoke to Woods Sr., and Woods Sr. had an order, a TPO. I don't know if it's the ex parte or the actual order, but he said he did look through it and it's on his body cam. But I don't know which one of the two orders or what order that he is talking about. And it's still your witness, so you can clarify it.
That's what I was going to do, Your Honor. Thank you. Now, officer, do you know which order that Mr. Woods Sr. showed you at that time?
It was a temporary protective order. I believe it was November. It was a 6-month or a year order, and it stated that he was not allowed to be within X amount of feet of the residence or Mr. Woods Sr.
Do you recall if it was an order, did it have the words ex parte on there, or did it say? You say it did say, did it say family violence 12-month protective order, or did it say something different from that?
I can look it up, but that sounds correct.
When you say you can look it up, are you looking at the notes you previously referred to that you attached?
I can review my body cam.
Yeah, maybe he'd be allowed to do that.
Okay.
And Judge, I'm gonna need a copy. You're gonna use it to refresh his memory. I need a copy.
You need a copy of his body cam?
Whatever he is going to use to refresh his memory, that's what I need a copy of. Yes, ma'am.
Judge, in that case, we would have to continue this hearing.
Officer Lewis, do you have a way that you can share the body cam with us now? And I don't know how your technology is set up.
I have a hard copy of the family violence order. I just need to verify that what I have was what he captured with his body cam. I can send that hard copy.
Can you send the hard copy and I can use that to refresh my memory?
I don't know if this is the one that you have. That's what we're trying to find out. If you give me the date that you have, I'll know if it's the hard copy that I have, and I can send that to Mr. Rogers. I just need to know what the face page says.
Judge, at this point, I'm objecting because that's not a question. She's essentially directing the witness to do things at this point. That's not a question. We're here for testimony, not for them to
Your Honor, I think right now,
coordinate whatever they're supposed to coordinate before the hearing.
Your Honor, you don't coordinate body cam footage because that's not something that we would normally do in magistrate court. However, since the defense has asked for a copy of that, what I am attempting to do now is coordinate so that he can have the copy that he asked for. So it's not a question in the sense of this is continuing the prelim. I'm trying to provide the material that he has asked for.
Not sure what that has to do. If the officer is finna use his body cam to refresh his memory, then I need whatever he's finna use. It's not for her to send because it's what the officer is using.
Exactly. I have a hard copy of I think what he has, but I don't know that until he looks at it. At which time he can tell me. Yes, ma'am.
Wouldn't a better approach just send it to Officer Lewis, email it to him, and let him see if that's the document he's seen or not?
I can.
And Judge, I'm gonna object to that because now she's providing him with the information. So even if it wasn't gonna be his answer before, after she gives it to him, it's gonna be his answer then.
We
Like
don't
he's
know
not.
that, Judge, because in the end, it's the body cam. If this doesn't match what he's looking at on his body cam, then this is not the correct document. And I will CC you on it, Mr. Rogers, and I will also CC the court so that everybody can look at the same thing.
Can't unring the bell though. Once he's seen it, then that is helping him to inform his testimony at this point. So I would object to the state providing him with any kind of documentation at this point. Like I said, they had time to do this
Wouldn't that
beforehand.
be, Mr. Rogers, wouldn't that be the same thing as her sending over a police report or whatever else?
If the officer was saying that he was using it to refresh his memory, that's one thing.
Yeah, he
If
said he
they-
saw the order. So had he not testified that he saw the order and he flipped through it and is on the body camera, then I would understand your position. But he himself said he saw the order, he flipped through it, and it was recorded on his body cam.
Right, but if I'm understanding, though, he's still gonna have to use his body count as part of this. And again, now to say that he's going to refresh it with something that she provides when he's got his own, his own way to refresh it, because there's no way to know that what she gives him is the same thing that he saw in the field.
And if he
Actually-
doesn't remember, he'll just say that I don't know. If it is, I don't know if I saw it or didn't see it. But what I guess my point is he's seen it before and it's on body cam. So sending them something he's already seen and he's already recorded. I guess I don't see your objection because he's seen it, so he can testify if he's ever seen a document or not, because he's already said he saw it. So if she sends it, he can say, nope, that's not what I saw. Or yes, that is what I saw.
Okay, Judge. I mean, if that's her ruling, that's her ruling, Judge. You're the judge.
All right. So would you please send it, Ms. Thomas, and let him
Yes,
look at
ma'am.
it and see if that's the document that he saw or didn't see.
And I will include the court and Mr. Rogers on.
Pardon me, Judge. May I make a quick announcement while everything's being done on this hearing?
Yes.
Judge, for Mr. Smith, DeAndre Smith, that will be a consent bond and waiver.
All right. Thank you. If you don't have anything else, you're excused.
Thank you, Judge. Have a good day.
All right. You all can bring Mr. DeAndre Smith back.
Officer, what's your email address?
jlewis@riverdalega.gov.
Don't ask it, because you was able to get a signature on it. That's what I went off. Go this way. Look at the phone. You can stay right there.
Who's that?
Smith.
I think that's Mr. Mondele's client, Judge.
Oh, he can go back to with the deputies. We're finished with him. He accepted I didn't know if you heard that. He accepted the bond and waived this case, Ms. Thomas.
Thank you, Judge. I just sent it to everyone.
I ain't never jump on. And charged with aggravated assault by strangulation that,
Mr. Woods,
We can hear you.
I was talking.
Mr. Rogers, did you get it?
yes, I did. Thank you.
Officer Lewis, did you have an opportunity to review it?
Oh, it's not letting me open it up right now.
Okay.
It still won't let you open it up?
She ain't doing that.
Yes, no, were you able to, you tried again and were you successful, Officer Lewis?
Yes.
Yes,
Yes.
as in successful?
Yes, I've been successful.
Okay,
Try to-
all right, Ms. Thomas?
Now, officer, have you been able to compare that document to the document you captured on your body cam?
This is the same document.
And that was provided to you by Mr. Wood Senior?
Yes. Upon our arrival, yes.
And I believe you previously testified that it had already been signed by a Superior Court judge of Clayton County, is that correct?
Yes, ma'am.
Okay. And did Mr. Wood Senior indicate that he had told his son or that his son had been advised about that document?
Yes, ma'am.
What did Mr. Wood Senior say? Do you recall?
He said that he had known about that his son knew about the temporary protective order, though when his son is not drinking and not on drugs, is what he stated, that he had allowed him to come to the house previously. But he was drinking that night, and that was the discrepancy.
What was your observation of his condition?
He was clearly intoxicated.
Okay. What did Mr. Woods Senior want you all to do? Did he indicate?
He wanted his son to just leave for the night, but given the temporary protective order, we had to.
You say given the temporary protective order, you had to do what?
We had to make the arrest because he was at the location where he wasn't supposed to be.
Okay. And I believe I've already asked you whether or not you had spoke with Mr. Woods Jr., correct?
Yes, we spoke.
And that conversation with Mr. Woods Jr., was that captured on your body cam also?
Yes, ma'am.
Okay. And your conversation with Mr. Woods, with both of them, all of that was captured on body cam?
Yes.
Okay. I believe that's all one more thing. Officer, the person that we've been referring to as Mr. Woods Jr., is he present in court today? Can you tell?
Yes, ma'am.
Can you describe him by physical appearance or article of clothing?
Black male, orange jumpsuit, white undershirt.
Okay. I believe that's all I have with the officer reserved right to redirect.
All right, Mr. Rogers?
Thank you. Officer Lewis, there's been a lot of conversation about Mr. Woods. I'll say junior, which is, if it's easy, I'll just say junior and senior. There's been a lot of testimony about junior saying that he was aware of ATPL. So I want to be very clear. Did you ask Raymond Woods Jr. whether or not he was aware of a TPO dated as of November the 10th, I believe it is?
I showed Junior the TPO and asked him if he was aware of that.
And
Say
it one more time.
That was captured on body cam.
In the courtroom, can y'all put Mr. Wood, can y'all put it on mute right now?
I'm muted.
Thank you. So, and just kind of, when you say you showed the TPO to Junior, are you saying you handed him the document that has been emailed to us and let him look through it? Is that what you're saying?
Yes, I showed it to him. I didn't hand it to him. He was in handcuffs.
So when you say you showed it to him, I just want to make sure we're being clear about what was shown. Like, do you just show him the first page? Do you flip through it and let him see the pages and the dates? How does that go?
I don't recall. I don't want to.
And as it relates to Mr. Let's see, I think you said Junior told you that Senior let him come to the house. Is that correct?
Yes.
Did you ask Senior about that?
Yes.
And if I'm understanding on the particular day in question, Miss Junior was saying he had been allowed. Well, let me ask, I guess, because do you know when Junior is supposed to have gotten to the house?
How long he was there previous to us being there?
Right, and that particular time that, yes, sir.
I'm not sure. I do recall Junior stating that he had been there for an extended period of time before that date.
Were you able to confirm that with Senior?
Uh, I'm not sure. Senior
And
did state that he had allowed his son there off and on for months.
did you all have any conversation about Junior being there to help care for his mom slash Mr. slash Senior's wife?
No, I believe, or no.
And if I understood you, Mr. Wood Senior is not even saying he doesn't want him to ever come back. He's saying he wants him to leave for the night. You're saying is what he told you.
Yes, sir.
Did anybody, and I know I asked it a little more specific earlier, but did anybody ever tell you why Junior was there? This like period prior to and on that day.
My understanding is they didn't have anywhere else to go. Um, yeah,
Do you recall who told you that?
both Senior and Junior.
No further questions at this time.
All right, anything else, 88 Thomas? Any follow-up?
No, Your Honor, not this time.
All right, any other witnesses or evidence?
Not from the state.
All right, Mr. Rogers, I'm assuming you're gonna call Senior?
Yes, ma'am.
All right. Could you all allow Mr. Woods Senior into the courtroom, please? And it doesn't allow me to unmute, so would you please unmute the device as well? Thank you. All right, Mr. Rogers.
Yeah. Mr. Wood Senior, can you hear me?
Yeah, I don't hear so good by eight.
Okay. I'll try to speak loud enough. If you have any trouble hearing me, just let me know and I'll repeat it for you.
Judge,
Um,
I'm sorry, Mr. Rogers, 1 second. This is a technical thing. There is a speaker at the podium. Can that be moved so that he can speak in that and he won't have to yell?
It's a microphone at that desk.
Oh, okay.
You just probably need to move it down.
and can we make sure it's on? Sometimes they're not turned on.
Can you make sure it's working?
I haven't been in that courtroom. I don't know how it's set
Mr.
up.
Wood Senior, could you say something into the microphone?
No, speak into my.
It's not on. You have to turn it on from the judge's desk. So he ought to stand up at the podium then.
I believe it's on, it's green, so I believe.
Oh, it's green, so he just might have to speak up.
So you gotta speak up into the mic. I don't know what you said.
Would it be okay? Can we try them at the podium? Is that possible? Or to move that?
You move back. No, you can.
And just swear in your witness, Mr. Rogers, before you start.
Understood. Can you hear me now, Mr. Woods?
Yeah.
Okay. Can you please raise your right hand?
Put your right hand. Put your right hand. Put your right hand on there. There you go.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yeah, I do.
You can put your hand down. And could you please state your name?
Raymond Woods.
And Mr. Woods, do you know the gentleman seated to your right?
What now?
I said, do you know the gentleman seated to your right?
Yeah.
Who? Can you please identify him?
That right here?
Yes, sir.
Yeah, my son.
Okay. And Mr. Woods, you recall law enforcement coming to your house and arresting your son recently?
Right.
Now, and we talked yesterday, Mr. Woods. To your recollection, I guess, is on that day, was your son there with your permission?
What you said now on that day?
On the day that he was arrested, was your son there with your permission?
Yeah, he was there with my permission.
And, again, like I said, I know we talked yesterday, but can you please let the judge know why you wanted him there?
Why I want him there? Why
Yes, sir.
do I want him there? Well, I need him. I need him because my wife just had a stroke and she can't do nothing for herself and I need some help. We both old. She's paralyzed. I got nurses at home now. Or, trying to help me out. So I just need him. And he didn't put his hand on me or nothing, but I had to TPO. And so I said, I won't tell him I got it long, he act right. But if he started cussing me and going on after I called the police. So that's what happened. I didn't want him in jail, I just wanted him to go. To go and then he could have came back later on. But that's what it was.
And I just want to make sure I heard you because sometimes it's kind of hard to make sure to hear everything correctly. Did you say you didn't mention the order to him?
I said I didn't want him.
No, it sounded like you said something about the order and not telling him. Do you recall just now, a second ago, you said something about I thought it sounded like you said you were going to have an order.
He said he has the order, but he didn't want him arrested. He just wanted him to leave for now.
Okay.
But he could have came back later, is what he said.
And At the time he was there, I want to make sure I'm understanding. You're saying at the time he was there, it was to help out with your wife?
Yeah, I'm having a problem with my wife.
I said, I was asking, was your son there to help out with your wife?
Yeah, that's what I needed for now. My wife had a stroke on the 15th of January, 15th of February. And she helped us, you know, she can't do nothing for herself. I'm 82 years old and I just need some help. And I got to trust him to help me. I just got to trust him to be there to help me out with his mother.
Understood. No further questions from me, Mr. Woods. Thank you.
All right, 88 Thomas.
Mr. Woods, can you hear me?
Yes, ma'am.
Great. Hi, I'm Andrea Thomas. I'm the ADA, okay? You can hear me?
So what now?
I'm the ADA, the district attorney. Okay, I'm the prosecutor. Okay, I'm gonna ask you a couple of questions.
Yes, ma'am.
Okay, you took out an order against your son?
Yes, ma'am.
You came down to the courthouse and the judge signed it?
Yes, ma'am.
That meant he was not supposed to come back to your house, right?
Yeah, I guess that's what it said.
Okay, and you didn't ask the judge to make it so he can come back whenever you felt like it, right?
No,
You wanted him gone.
I didn't ask the judge. The paper that she gave me, I know it was a TPO, never read it, or they said they would give him a copy of it, you know.
Okay. And did you tell the police that when they got there that night?
Yes, ma'am.
You showed them that same piece of paper that the judge signed?
Yes, ma'am.
And your son knew about that paper too, right?
No,
He did not, or he did?
he did not.
You never showed him the piece of paper?
He gave me the paper. I didn't tell him. Here's what I said. I said, well, if you do right, I won't worry about it. So I never showed him my paper, but he said they were gonna serve him one. So evidently they never served him
How
one.
do you know?
I don't know. I just they evidently didn't, because I believe if they had a certain one, he'd have left.
Now, you had to let him come back to your house, correct?
Yeah, I let him come back.
Yes or no?
Yes, ma'am. I let him come back.
Okay, I can't hear you that good. I'm a big old head on the wall, so you're gonna have to talk up for me, okay?
Yeah.
Did he tell the police he knew about it?
Did he tell the police?
Yes, that he knew about that order?
But I'm gonna object. Partly to that would call for speculation. There's been no foundation laid to say whether or not he would know one way or the other how he would have to know.
Yeah, this is actually a yes or no question. Either he heard him, or he knew, or he didn't.
I don't
Right.
know.
My point is,
Hold on, Mr. Woods. Hold on 1 second.
Ms. Thomas, what was your question again?
Did he hear his son? Wait a minute. It wasn't that complicated.
that's a different question. If she asks that question, I can withdraw my objection.
That's not what I said, Mr. Rock. Give me a minute. I'm trying to reframe this. I asked him, did his son tell the police he knew about it?
I don't know what he told the police.
Hold on, Mr. Woods. Hold on. I think you're answering it, but hold on.
Just hang on.
I withdraw my objection, Judge. He already responded.
Okay, all right, next question.
And I think you said he did. You don't know if he did or he didn't. Is that what you said? I heard you right.
All right, she's talking to you now. Yeah, I don't know what he told the police. When the police came, they carried him. I stayed from the police, and they carried him right to the car. They talked to him.
Okay. And what was going on with him that night that you called the police?
The only thing that went on, he just started cussing and calling me out my name. I was already upset on account of my wife. You
Okay.
know? So, and I just didn't want to hear it, so I just called the police and showed them a piece of paper. That's what happened.
Had your son been drinking that night?
I don't know whether he was drinking or not, but I think so.
Okay. Was he able to help you with your wife?
Not, but at that time, she was in the hospital.
Okay.
At that time, she was fit in the hospital.
Okay. Okay, so she wasn't there.
I didn't need no help then, so she left
Okay.
the hospital. And
She home now?
She had to a nursing home. She's at home now. Hospital care at home hospital care.
Yeah. Yeah, that's all I have.
All right, anything else, Mr. Rogers?
No, ma'am, just argument, Judge.
Okay. All right, I hear, Ms. Thomas, are you reserving your right to go last?
Yes, ma'am. Yeah, can we advise Mr. Woods what's going on? Because he's still standing there.
Mr. Woods, you can have a seat in the chair over there. All right, Mr. Rogers.
Thank you, Judge. So a couple of issues here, Judge. Number one, the state hadn't, they just said he was given notice. So that's what I'm gonna start with. Number one, they haven't offered any evidence of that. There's nothing that he signed, no photos shown, anything to say that there was any sort of service notice or anything like that given to him. The officer said that Junior acknowledged it once it was shown to him, but again, he's not even saying whether or not he showed him the particular order that's at issue here, as far as giving him a chance to see the date and things of that nature. There's no discussion about the date of the order or anything like that. So I would say that that's my first issue, is that it's not clear that he was ever informed of it. Number two, anytime we're talking about aggravated stalking, regardless of whether or not there's notice or not, if the person has notice, there's still a statute that covers it, 16-5-91. What it requires is that contact of the person, I guess, covered by the order be without the consent of the other person. That's not what we have here. So it fails at that point, because you have the consent of the subject of the order, Mr. Woods Sr. He just said he was there with his permission. Also spoke about the reason he was there, which is, I guess, the second set of elements, that the contact would have to be for the purposes of harassment or intimidation. And you need both of those. You need it to be without the consent. Well, let me back up. You need to be, number one, under an order, which I'm not contesting the validity of the order, but I don't think there's been enough evidence of the notice. The contact has to be without the consent. That's not the case here. And it has to be for harassment or intimidation. That's not the case here. For those reasons, Judge, I'd ask that the case be dismissed for lack of probable cause. At the most, it's arguably, I guess, a misdemeanor violation of a protective order. But even, I would say, the spirit of it, Judge, I would ask for a complete dismissal, because he's there with the permission of the person covered by the protective order. So I would ask for that dismissal, Judge. Thank you.
All right, ADA Thomas.
Your Honor, just saying up front, because Mr. Woods Sr. is sitting there, I do personally understand what he is going through. Having a loved one that has had a stroke, is going through hospice, and you're the one that have to take care of them. I don't wish that burden on anyone. Having said that, Mr. Woods Jr. is no help to Mr. Woods Sr. to the point where he's had to take out at least 2 TPOs based on the officer's testimony that we know of. Apparently, he's a good son when he's sober, but apparently he's not sober enough for Mr. Woods to have to come down here and get help from the court. And Your Honor, the most recent TPO is a TPO that Mr. Woods Jr. violated. I wish I could say something different, because I do understand Mr. Woods Sr. needs help. but this man is not to help. Now, I've looked through that TPO, and unless I've missed something, there is no special section where you can just come by whenever. Those TPOs are pretty straightforward. You need to no contact, stay away. And that's what this one is. I believe the officer himself acknowledged that Mr. Woods Sr. told them at the time that he did not want his son to go to jail. I understand that. But as the officer said, the TPO does not allow that. If they come out and they find that the conditions merit it, Mr. Woods Jr. is required to go to jail, which is where he has been ever since. Now, Your Honor, Mr. Woods Jr. acknowledged knowledge of the TPO. Mr. Woods Sr. says he's not sure, he doesn't know if he was or he wasn't. But we know he was because I've got a proof of service that I provided to the court and to the defense. We know he was because he told the officer. So at this point in time, I understand Mr. Woods Sr.'s concerns. I understand Mr. Woods Sr. may need help. But, Your Honor, at this point in time, I do believe there is sufficient probable cause for this case to be transferred to the Superior Court.
All right, after hearing evidence and testimony, and based on the statute, is specifically, as Mr. Rogers pointed out, it has to be without the consent of the purpose and for the purpose of harassing and intimidating. And also, we don't have any evidence that he was served with the permanent TPO, and even the one that was shared with the court was not admissible because there's no foundation for it to be admissible. So there's no evidence of notice that was presented. So the court finds insufficient probable cause. This matter is adjourned.
Thank you, Judge.
You're welcome.